Can the Radekis hear me okay?
Yes, I can.
How about the DeKreigers?
Yes, we can.
Okay. I had it in my notes. The other thing that I need to cover with the attorneys is that I wanted to disclose that I do know John and Jessica DeKreiger. I do not know them well at all. I see Jessica periodically at Tamarack in passing, and I would say once every 3 to 6 months, it's been quite a while, I would run into John at breakfast at the Lumberjack Shack. But I know them just from being around town. I would say that we're friendly, but not necessarily friends. I don't know if we've ever done anything socially, but I wanted to let you know that I do have that connection with them. I don't think it rises to the level that I would disqualify myself from this case, but I wanted to let the parties know that I do have that familiarity with them.
Thank you.
All right, so with that, for the DeKreigers and the Radekis benefit, I had an opportunity to talk logistically with the attorneys about how do we balance giving the parties time to prepare and make their arguments and work up their case with kind of the emergency nature of a temporary restraining order granted without hearing, and to give the parties some sort of clarity, at least how we're going to operate going forward. The court is going to enter an amended temporary restraining order. This temporary restraining order is going to be valid for 90 days from today. What the temporary restraining order is going to say is that this disputed triangle of property is going to be divided in half, that the DeKreigers will have the exclusive use of the half of that triangle that abuts their lots. The Radekis are going to have the exclusive use of half of that triangle out for a bench trial on the issues. Mr. Berry or Mr. Olson, do you have any preference as to that timing? Would you want your hearing within 6 months?
Yes, Your Honor, I'd prefer 6 months.
Mr. Berry, does that work with you?
That's fine.
Okay, so I'll issue a civil scheduling order that will that'll give the parties 120 days for discovery. This is not a case that would be ripe for case evaluation, and I would ask the attorneys if they know, is this something that mediation would be effective, or do you think that you can try to reach a resolution just between you and your clients and the attorneys without ordering official mediation or facilitation? Mr. Berry?
I'm sorry, you directed that to me. I guess I don't know whether or not we can resolve it between myself and Dan on behalf of our clients until we get a little bit further into this. So if the court would like to order it, maybe reserve that portion.
All right, we'll set a pretrial conference. That'll be just outside of the 120 days. And at that time, we'll determine whether mediation, I mean, we're not talking about that much property. It sounds like the parties got along okay up until recently. In my experience, both Mr. Berry and Mr. Olson are reasonable attorneys. So my thought was that if an agreement could be reached, that they have the skills to do that. You wouldn't necessarily need to bring in an outsider to try and do that. But if my impression turns out to be wrong, I do reserve the right to order the parties to facilitation. We'll probably find a trial date for you within 6 months, and we'll probably include that in the civil scheduling order. I don't usually do that, but I don't want to have the dates get booked up and not have something within 6 months. So we'll include a one-day bench trial date in that civil scheduling order. All right?
Very well. Thank you, Your
Thank
Honor.
you.
All right. Thank you. And I got to get to my next hearing, so thank you.
Okay, take care.
Thank you.
I'm going to be admitting Attorney Zelensky and Attorney Partridge.
You ready? Okay. All right, so we'll next take up the case of Joseph Jarecki versus USAA Casualty Insurance Company. This is case number 19-20580. I first want to apologize to the attorneys. I was on another Zoom hearing with I can't hear you, Mr. Zelensky. You were talking, but I didn't hear you.
I apologize.
Okay. There you go. I don't have to hear everything you say, but I just wanted to make sure that you weren't muted.
Yep.
So I was on a hearing on a preliminary injunction on a property case, so it ran a little bit long, so I apologize for not starting this hearing promptly. So this hearing, we're scheduled for the court to determine the amount of attorney's fees that would be awarded to USAA in this case. And I guess I would turn it over to you, Ms. Partridge, any argument that you would like to make?
Your Honor, I'm assuming you've already reviewed the briefs and are familiar with the issues and the arguments made, or would you like a summary?
I don't need a summary. We've been over it a few times. I have read your brief and your motion, and I've reviewed the bill as well. So is there anything that you want to add to what you've already submitted?
Yes, Your Honor. I guess I'll just rebut the plaintiff's response brief, which was filed late, and so I suppose I should place an objection formally on the record on that. But Your Honor, in terms of some of the comments that were made in that response, USAA is asking for a reasonable amount with the 2.1 hours for having to attend the hearing regarding the objection that was filed. That was not simply a bill for reviewing the document itself. That was the total time cumulative to attending the hearing, reviewing the objection, looking at the court rules and case law, and preparing for the hearing. So, and I didn't include all of the time that I spent reporting to USAA or having to clarify the order issue or reviewing the renotices, all that good jazz. And then, Your Honor, with respect to the plaintiff's comments about COVID being a reason for delays or issues, I would say, Your Honor, that COVID actually probably helped the plaintiff's attorney in terms of the fact that the hearing was attended via Zoom. It did not include or require travel time to and from my office to the Newaygo County Circuit Court. And so, and mileage expenses were not incurred with respect to having to attend that second hearing with respect to plaintiff's frivolous objection. And I also didn't bill any time with respect to preparing this motion to determine the amount of the fees. Your Honor, I think that the amount that was requested was reasonable, quite frankly, below the 25th percentile in a lot of the categories. And if there's any adjustment to be made to the amount, I would request that it actually be increased as opposed to decreased.
All right, so the one question that I had for you, Ms. Partridge, I was wondering if you could expand on any attempts that you had with Mr. Zielinski to clarify or explain why what he had submitted in February was not what you were looking for, or not what was in response to the interrogatories that were submitted.
Yes, Your Honor. I did send a follow-up letter to Mr. Zielinski. I believe that was attached to my original motion to compel. We talked afterwards with respect to, and over the phone, I believe Mr. Zielinski discussed it in his response brief. And I mentioned it before at the hearing, at the original hearing in the motion to compel. So it's discussed in the transcript that Mr. Zielinski attached. But we did talk it over, Your Honor. I explained to him exactly what it was that I was looking for. I didn't think that he understood, because he kept talking about new claims and still not understanding that what I was looking for or what overdue damages or what claims had been submitted and had not yet been paid. That is the issue that was discussed multiple times at all of the hearings and at the motion to dismiss. And again, we did have conversation both via correspondence and via telephone, and it just didn't result in anything.
All right, thank you, Ms. Partridge. All right, and now turning to you, Mr. Zielinski, a couple questions for you. What day and what time did you submit your response to plaintiff's request for attorney's fees?
Your Honor, it was overdue. The answer to that would have been yesterday. I believe I submitted a judge's copy as well as a copy for the court clerk yesterday at about between 12 and 2. I believe it was off the top of my head.
Okay, and what do the court rules require in terms of service of a response to a motion?
Your Honor, I would have to re-review the court rules, but I believe it's at least 4 days for a response. I could be wrong. It might be 7. I would have to review that particular court rule for a response, but I believe it's 4.
Right. And do you agree that the response that you filed does not comply with the court rule, with whatever it says?
Your Honor, I do, and I greatly apologize about that. I am aware of that, yes.
All right. A next question for you. What was the total amount of pages that you submitted to the court yesterday afternoon with your response?
Sure, Your Honor. With my exhibit of my discovery, the plaintiff's original discovery responses, which was lengthy, was one exhibit, and that was probably at least 80 or 90 pages. So along with the transcript, it almost was about 150 pages. And I obviously see where this is going, and I greatly apologize for the extensive exhibits, primarily the discovery responses. I just put that in there, Your Honor, to let you know that even from the beginning, the first initial discovery responses from plaintiff to defendant, it's not like we were trying to be deficient, and that was the purpose of me attaching that as an exhibit, nothing more. I apologize for rushing the court, and I knew that, again, on behalf of plaintiff, that it was not filed in time. It was obviously with the weekend, and that's an error on behalf of my office. But the reason that it's lengthier is because I did attach plaintiff's response to the document requests as well as the interrogatories, which were provided in February. And Your Honor, I would just like to say is many times before the original motion to compel was filed, I attempted to get a hold of Emily Partridge and her office. Many times I spoke with her assistant. His name is Chris. I spoke to their secretaries to try to let her know that if anything, I would like the motion to compel. The first one, even though I believed we had provided information at that time, to ask to at least push it because my small practice, again, I wasn't able to get coverage in that, and I, was on the other side of the state. And so I would like to go off the record briefly, if possible, before the end of this, but that's just something that I wanted to indicate is that plaintiff in our office did attempt to correspond with defense counsel's office before. I mean, I have emails reaching out to her staff, and I attempted to get a hold of sister counsel, days before to try to continue to clarify what exactly she was looking for. Your Honor, I don't want to continue to see like I'm going on a rant, but again, in good faith, plaintiff attempted to work out discovery motions with sister counsel's office from the outset. There was no attempts of trying to surprise attack with discovery or anything of that matter. And so, quite frankly, my office is humbly apologizing to the court for placing, the court in this position. And with that, plaintiff will rest. Thank you.
I do have another question for you.
Yes, Your Honor.
In one of the exhibits to the motion that was attached by Ms. Partridge, there was an email exchange between the two of you, and you made the reference that Ms. Partridge was lucky that I was the judge in this case, and I'm wondering what you meant by that, to the extent of, do you think that there's some pre-existing relationship, some conflict of interest?
Absolutely not, Your Honor.
Or something like that?
Absolutely not, Your Honor.
That statement goes to?
Absolutely not, Your Honor. All I was indicating, and I would like to go off the record if I could, but if you're not comfortable with that, all I was indicating to sister counsel was that I was unfamiliar with the Newaygo Circuit Court, and I'm not unfamiliar with Bishop Court rules, but I was unfamiliar with this particular court and how it was ran. And I'm a younger attorney, Your Honor, and I'm more familiar with the courts over here in Wayne County, Macomb County, and even Oakland. That's that was what that was going to. It was nothing of any other indication other than unfamiliarity with the Newaygo Circuit Court and the Circuit Court room. And Your Honor, there was meant to be no other inference.
So, but the word choice of lucky kind of leaves me wondering if that's what you really meant, was that you were unfamiliar, but you used the word lucky, which has kind of a different connotation than what you're describing.
Your Honor, maybe go off the
today.
record, please.
All right, we'll go off the record. We'll stop the live streaming and we'll go off the record for a moment.
Give me 1 second.